every bank is foreign. Every single one of them. So here we have it, the proof that all banks are foreign entities and that they cannot sue you in state court or federal court for that matter. But right now we're going to talk about why they can't do shit to you in state court. And I want to thank Carl Collicott and Derek Gonzalez for their gracious giving of their knowledge. All right, this one's going to be a long one, so I hope you brought your pencils. But real quick, I do for you, you do for me. In my bio, my new stand store is up and running. You can go there and book a one-on-one with me. You can also download some of the files that I'm starting to compile there. Thank you very much. That's all I have to say. Get your pencils ready. Here we go. All right, did y'all know that in 1989, the Department of Justice itself, the DOJ, handed over an amicus brief for Citibank N.A. versus Wells Fargo Asia Limited, right up here in the Supreme Court, and yet we've got the Kool-Aid crowd still waiting for the FBI to come save us from banking fraud. Okay. Anyway, the Supreme Court recognized that the United States banks, like Citibank N.A., are simply foreign banking entities wrapped in U.S. charters, playing by international rules, and even the DOJ backed this up, that there's no magical domestic banking shield that allows them to hide behind state courts or claim American jurisdiction when their entire banking structure is tied to foreign branches, foreign assets, and international banking law. This case straight up asked, can a so-called United States bank even be held liable for deposits in a foreign branch? And then here came the reality check. There ain't no such thing as a United States bank. 12 U.S.C. 3105 and 12 U.S.C. 631 admit that these are foreign entities operating under foreign banking charters regulated by the Bank for International Settlements, not the United States. The DOJ literally confessed that national banks like Citibank are foreign banking operations serving the foreign commerce of the United States. That means that every so-called U.S. bank is foreign in structure, regulated from abroad, and only permitted to dabble in domestic commerce by grace of the federal government. So, for all you guys still clinging to the idea that Synchrony Bank or Citibank or any of the usual suspects can sue you in a state court because they're domestic, think again. Next time before you show up with your half-baked comments and your kindergarten legal takes, maybe try reading the federal code. And speaking of the federal code, I hope you sharpened your pencils. 12 U.S.C. 1841 Bank Holding Company Act of 1956 defines a bank holding company as any company that owns, controls, or has power over a bank. Foreign banking organizations and parent corporations of U.S. banks that are domiciled outside the U.S., controlling vast parts of the U.S. financial system. The key insight here is that even these U.S.-based banks are often subsidiaries of the foreign holding companies. Not often, actually, they are. 12 CFR 211 Regulation K, International Banking Operations, governs foreign banking organizations and their U.S. branches. This explicitly states that foreign banks' U.S. activities are limited to foreign business and domestic transactions with U.S. citizens, which must be authorized under strict rules. The key insight here is that if a bank operates inside the U.S. under this regulation, it's a foreign entity subject to foreign law and international compliance. 12 CFR 211.21 to 11.24 Definitions and Restrictions. This defines a foreign bank as any institution organized under the laws of a foreign country and engaged directly in banking outside the United States. Domestic branch of a foreign bank is merely a branch authorized under U.S. regulations for foreign operations. Your key insight here is that a U.S. branch or subsidiary is a domestic arm of a foreign banking operation, not a truly domestic institution. You starting to see a pattern? 12 U.S.C. 1843F, exclusion from public banking. Foreign banks are prohibited from transacting with the U.S. general public unless explicitly authorized. This confirms that most banks in the United States are simply foreign extensions under U.S. regulatory tolerance, not truly American institutions. Historical context and Federal Reserve setup. The Federal Reserve Act of 1913 created the modern banking framework. Many banks are chartered under federal law, but owned or controlled by foreign interests. The Bank of International Settlements, BIS for short, and foreign-controlled institutions oversee much of the regulatory framework, including Basel Accords, directly influencing U.S. banks. A bit of case law for this one. National Bank versus Matthews and First National Bank Bel Air versus the Comptroller of the Currency. These cases, both of them confirm that no bank in the U.S. can secure loans with real property. This ties into the distinction between domestic banks and the underlying foreign ownership of foreign regulatory frameworks. The Supreme Court filing just reaffirms the most obvious. As of 1918, no entity operating under the provisions of the 1913 Federal Reserve Act has ever been permitted to accept a deposit from an American citizen. 12 U.S.C. 461B is merely a codification of Section 19B of said act, restricted to bankers' banks. Bankers' banks, restricted to transactions with other financial institutions outside the United States, and they're not permitted to conduct business with the general public or accept a deposit from any entity other than a financial institution, by definition a branch of a foreign bank. Congressional intent of the restrictive nature of the 1913 Act is reflected in some of the following code and provisions. 12 U.S.C. 615 prohibits the acceptance of a deposit from an American citizen. EDGE Act corporations, agreement corporations, people like Bank of America, Chase Bank, Citibank, U.S. Bank, all of them, subject to 12 U.S.C. 615, are not permitted to accept a deposit from an American citizen. What's a deposit? Federal savings associations, federal credit unions, depository institutions are not permitted to accept a deposit from an American citizen. Bank holding companies, Wells Fargo, SunTrust, all of those, restricted to 12 U.S.C. 1843, are not permitted to accept a deposit from an American citizen. Bank service companies, including MERS, you ever hear of MERS? Codified at 12 U.S.C. 1861 through 1867, are not permitted to accept a deposit from an American citizen. Foreign banking organizations, Deutsche Bank AG, Credit Suisse, Bank of Scotland, Citigroup of Ireland, HSBC of Singapore, are not permitted to accept deposits from American citizens. Your source, Citibank N.A. petitioner versus Wells Fargo Asia Limited in the Supreme Court of the United States, October term 1989. The federal government has drawn other important distinctions between the United States banks' foreign and domestic deposits. For example, Congress has dictated that federally imposed reserve requirements on deposits shall not apply to deposits payable only outside the states of the United States and the District of Columbia, 12 U.S.C. 461b6. This exemption, which was codified in 1980, reflects a Federal Reserve Board practice dating back to 1918. Regulations concerning this, 12 CFR 204.121, bankers' banks deemed adopted in order to deceive, fictitious, pretended, feigned. 12 U.S.C. Code subsection 371C, banking affiliates. For the purpose of this section, any transaction by a member bank with any person shall be deemed to be a transaction with an affiliate to the extent that the proceeds of the transaction are used for the benefit of or transferred to the affiliate. Here come the federal laws, regulations, and codes. 12 U.S.C. 29 prohibits banks from holding or transacting in real estate beyond limits set for banking purposes. National Bank versus Matthews. 12 U.S.C. 503 imposes personal liability on bank officers and directors for unlawful lending practices and false record keeping. 12 U.S.C. 615 limits banking organizations' transactions inside the U.S. to those incidental to foreign business, prohibits holding property except to cover prior debts. A lien on a mortgage? 12 U.S.C. 1847 imposes severe penalties, including up to $1 million a day for violations by banks and their agents, including fraudulent conduct in the United States. 12 U.S.C. 1861 through 1867, the Bank Service Company Act, specifies that bank service companies' permissible activities are limited to functions like providing courier services and not banking or lending to the public. 12 U.S.C. 1972 prohibits banks from engaging in certain non-banking activities, especially with the public, unless explicitly allowed by Congress. 12 U.S.C. 501A provides for forfeiture of a national bank's franchise for failure to comply with these laws. 12 CFR 5.34E5V limits national banking operating subsidiaries to functions like courier services, excludes lending and financial transactions with the public again. 12 CFR 204.8 restricts international banking facilities to service foreign clients, prohibits domestic lending and deposit taking. 12 CFR 211 Regulation K governs foreign banks and holding companies, confining their U.S. activities to branches for foreign banking business, not general U.S. public lending. 12 CFR 225.28 lists permissible non-banking activities of bank holding companies outside the U.S. Domestic banking with the general public is excluded. 12 CFR 347.105 explicitly states non-bank finance companies are only authorized for activities outside the United States. 12 U.S.C. 378 makes it unlawful for securities dealers to engage in banking or accept deposits. 12 U.S.C. 78C defines securities and requirements for disclosures in transactions relevant to mortgage securitizations. Hell, I even got the state of Florida statutes right here. International bank agencies' permissible activities. An international bank agency may not receive deposits in this state except deposits from non-resident entities or persons whose principal places of business or domiciled are outside the United States, or interbank deposits, interbank borrowing, or similar interbank obligations, notwithstanding the provisions of subsection 1, or any international banking corporation organized and existing under the laws of any other state and licensed to operate an international bank agency may engage only in those activities permissible for EDGE Act corporations organized under Section 25A of the Federal Reserve Act as amended 12 USC subsection 611 through 632. 663.602. International representative offices. Permissible activities. An international representative office may promote or assist the deposit-taking, lending, or other financial or banking activities of an international banking corporation, but a representative office may not conduct any banking or trust business in this state. It's from the state, guys, from the state. State chartered investment companies, formation, permissible activities, restrictions. With the approval of the Office of Florida Corporation may be formed for the purpose of engaging in international banking, lending, and other financial activities. A state chartered investment company established pursuant to this section shall engage directly in only those activities permissible for an EDGE Act corporation organized under Section 25A of the Federal Reserve Act as amended. The state of Florida said they can't do business with you. I don't know if that's proof enough. We're going to keep going. Youngstown Sheet and Tube Company versus Sawyer emphasize that Congress cannot be presumed to grant powers that they have not explicitly given. That means that if it wasn't in the fucking code, you're not allowed to fucking do it. You're not allowed to do business with me. Not in this state. You can't sue me in state court or federal court. But anyway, National Bank versus Matthews, 98. U.S. 621, 1878, the Supreme Court decision held that a mortgage or any other real estate security taken by a national bank is void. When I said all contracts, I meant all contracts. They cannot do business with you. United States versus Curtiss-Wright Export Corp. clarified the fundamental separation of domestic and foreign powers used here to argue against domestic banking activities by foreign entities. I forgot this one. First National Bank Bel Air versus the Comptroller of the Currency. It reiterated the limitations on banks securing loans with real estate. Red Cross Line versus Atlantic Fruit Company asserts that a contract is void if the means of enforcement are lacking. Any contract, again, any contract is void if the means of enforcement are lacking. There's no jurisdiction that cannot enforce it. Notable points for you guys to pay attention to, and we're going to keep going. No lawful authority exists for banks or foreign banking entities to directly lend to you, a U.S. citizen, or use real estate as a security in several states unless specifically authorized by Congress, and they didn't authorize it. All mortgage-backed securities and securitization schemes involving U.S. real property violate outlined statutes when conducted by foreign banks or unauthorized entities. They're all not authorized to do business with you. Private right of action under 12 U.S.C. 503 is going to provide a basis for you to challenge unlawful banking practices. Mail fraud, extortion, and securities violations under 18 U.S.C. 1005 and 1951 can be implicated in schemes involving unauthorized lending and securitization. Examples of U.S.-based banks owned and controlled by foreign banking organizations. Here comes a short list. HSBC Bank USA, N.A., a subsidiary of HSBC Holdings, headquartered in London, one of the largest banking groups globally, operated through a U.S.-based subsidiary but controlled by a foreign parent. BNP Paribas USA, a subsidiary of BNP Paribas SA, headquartered in Paris, operates U.S. branches and affiliates, but the parent ownership is entirely French. Barclays Bank, Delaware, a subsidiary of Barclays PLC, operates U.S. consumer lending and credit card operations, but it's foreign controlled. Santander Bank, N.A. How many of you got a car loan through them? Subsidiary of Banco Santander S.A., headquartered in Spain. One of the largest foreign banking organizations operating in the U.S. through multiple branches and lending platforms. Bet you thought they were out of Texas, didn't you? TD Bank, N.A. Hey, these are all over Florida. Subsidiary of Toronto Dominion Bank, headquartered in Toronto, Canada, which I think they're a state now, right? Operates one of the largest U.S. consumer banks under foreign ownership. Mizuho Bank, USA. U.S. operations of Mizuho Financial Group are headquartered in Japan. They're a major player in U.S. commercial and investment banking under foreign control. Deutsche Bank Trust Company Americas. They are a subsidiary of Deutsche Bank AG, headquartered in Frankfurt, Germany. Operates U.S. commercial banking, investment banking, and wealth management under German control. Listen, the key insight takeaway from this before we move on to the U.S. banks who are foreign controlled is that this list is very condensed. Every bank is foreign. Every single one of them is foreign. And even though these banks operate branches and subsidiaries or entire U.S. brands, right, their true ownership and control lie in foreign jurisdictions, making them foreign banking organizations under U.S. law 12 CFR 211. It's that simple. U.S. banks with foreign ownership or foreign regulation connections. Bank of America. They are perceived as a U.S. bank headquartered in Charlotte, North Carolina. However, its corporate structure connects to international banking regulations. They operate significant foreign branches and subsidiaries. They are subject to Federal Reserve and Basel Committee regulations, aligned with Bank for International Settlements, which is a foreign-controlled entity, the Rothschilds. Bank of America's top-tier parent entity is Bank of America Corporation, which holds foreign banking licenses and is regulated under 12 U.S.C. 1841 as a bank holding company, placing it under the same regulatory umbrella for foreign organizations. Capital One Financial Organization, I bet you thought that they were American, didn't you? Technically headquartered in McLean, Virginia. I've sent many letters there. Function as a bank holding company under the Federal Reserve with international activities and foreign regulatory influences. Capital One N.A. and Capital One Bank USA N.A. are based in the U.S., operate under holding structures that include foreign compliance and regulatory obligations. They're foreign. Discover Financial Services, known for credit cards and banking, they're based in Illinois. While Discover itself doesn't have a foreign parent per se, it operates heavily in international banking and payment networks. Diners Club International will be one of them, with regulatory connections that pull it into the global system governed by foreign banking regulations like Basel III. Additionally, Discover Bank is a subsidiary of Discover Financial Services, which, like other major U.S. banks, is subject to foreign regulatory agreements through the Federal Reserve and international banking treaties. Even if a bank like Bank of America, Capital One, or Discover appears domestic, their functional regulation and compliances are set by foreign-controlled entities. BIS, Basel committees, IMF, all of that. In effect, they're operating as foreign institutions under U.S. banking law. Here comes a big one for you, and I know you didn't want to hear this one, but it's Synchrony Bank. Parent company, Synchrony Financial, SYF, listed on the New York Stock Exchange under the SYF ticker. Established after a spinoff from General Electric, GE Capital, in 2014. Synchrony Bank was originally part of GE Capital Retail Bank, a division of General Electric, which was heavily involved in international and U.S. finance operations. When Synchrony Financial was spun off, GE retained no ownership, but the bank remained under regulatory frameworks that integrate with international financial systems, including Basel III and BIS guidelines. Foreign connections. While Synchrony Financial is a U.S. domiciled holding company, it operates under Basel Accords compliance, similar to other major U.S. banks, effectively aligning it with international banking regulations. Synchrony's credit card securitization and consumer lending operations often involve global investors and compliance with international finance standards. Key takeaway here: while Synchrony Bank itself is U.S.-based, its historically GE Capital roots, regulatory compliance, and global investor base mean it is part of an international financial ecosystem. That's not the kicker. Now here's something that I want to leave you with. AIG versus Bank of America, Kirshner versus JP Morgan Chase. The banks themselves, Bank of America, Chase, Synchrony, Discover, Capital One, all of them, every single fucking one of them have argued that anything, and let me say that again, anything concerning any transaction with them is beyond the state's jurisdiction, that a state court cannot adjudicate any matter involving them. And here's an example of where the banks argue that any case which names any of them is solely under federal jurisdiction. So yeah, if the fucking banks believe that they are beyond the state's reach, then we should probably agree with them. Although that argument was shot down and the district courts sent it back to the state. I'm sure that this has to do with it being on the record that the courts disagreed in case you or ever I try to sue in federal court. But I'll say it again, if the banks think they are without the state, then I'm going to back them 100% because I know which laws they are breaking and I know that they can be held accountable. So to all you keyboard warriors insisting that Synchrony Bank or any of these glorified foreign-controlled fronts can just walk into state court like they own the fucking place, congratulations on playing a game of checkers while the rest of us are playing 4D chess. Next time, maybe brush up on who's really pulling the strings before coming to me.